is a major update in the Karen Reed case, which ended in a deadlock and the prosecution promising to retry Karen Reed. Now, one of the major problems, and people called this out, was that Judge Beverly Cannone didn't give any opportunity for the jurors to say if they may have actually acquitted on one or more of the three charges. And during deliberations, they were asked to make considerations on three different counts: one, murder in the second degree; two, manslaughter while operating a motor vehicle under the influence; and three, leaving the scene of an accident resulting in death. And today, the defense has filed a motion to dismiss and a supporting affidavit. And in that, we find that three jurors are willing to be witnesses to tell the court that the jury was unanimous and in agreement that they wanted to acquit on count one and count three, which means if the prosecution decides to pursue a retrial, the only count that should be on the table is two, manslaughter while operating a vehicle under the influence. So let's first go through this affidavit from defense attorney Alan Jackson in support of defendant's motion to dismiss, and then we'll look at some of the motion to dismiss. Shout out to Ted Daniel for supplying these documents. So I, Alan Jackson, declare, I am a partner at the Los Angeles law firm of Worksman, Jackson and Quinn, and I've been licensed to practice law since 1994. I am counsel for Karen Reed, appearing on her behalf in the Commonwealth of Massachusetts pro hoc vice. On Tuesday, July 2nd, 2024, I was contacted by Juror A, true name and identity withheld to maintain anonymity. Based on my conversation with Juror A and that juror's description of who he or she is, where he or she was seated, and certain identifying information like name or occupation disclosed during the voir dire process, I was able to positively identify which juror he or she was. Juror A told me that he or she was seeing inaccurate reports about the split among the jurors related to the mistrial that the court declared the day before. Juror A stated that he or she wished to be respectful of the privacy of the deliberative process, but did wish to inform me of the true results of such process. Juror A indicated that he or she believes it is important to disclose such results because he or she believes that those results significantly impact Miss Reed's rights. Why? Because we're going to get into double jeopardy here. If a jury didn't have the opportunity to be heard that they wanted to acquit someone on one or more charges, and now the prosecution plans to recharge Karen Reed with those same charges, that could be an issue of double jeopardy. Juror A told me that the result of the deliberations was that the jury unanimously agreed that Karen Reed is not guilty of count one, second-degree murder. Juror A was emphatic that count one, second-degree murder, was off the table, in quotes, and that all 12 of the jurors were in agreement that she was not guilty of such crime. Juror A told me that shortly following that determination regarding count one, the jury also unanimously agreed that Karen Reed is not guilty of count three, leaving the scene with injury or death. On July 1st, 2024, when the jury presented a note to the court, all counsel were ordered to the courtroom. The note was not presented to counsel for review. Rather, the court indicated that the jury was at an impasse. Once the jury was seated, the court then read the jury note verbatim in open court, and without providing any opportunity for defense counsel to be heard, the court declared a mistrial and excused the jury. Now, why is this a problem? Because neither Miss Reed nor her counsel consented to the entry of the mistrial. Defense counsel was denied the opportunity to request that the court inquire on which count, or counts, the jury may have been deadlocked, including lesser included offenses, and on which count or counts the jury may have arrived at a verdict. Nor did the court, on its own, inquire of the jury foreperson on which counts the jury was at an impasse, and whether the jury could or did reach a unanimous agreement on any of the other counts. Had the court so inquired, it appears clear that not guilty verdicts would have been recorded for count one and count two. Miss Reed was denied her right to receive those verdicts in her favor. The foregoing is true and correct to the best of my knowledge and belief under penalty of perjury under the laws of the United States and the state of California and the Commonwealth of Massachusetts. And then he executed this affidavit on July 3rd. And this affidavit is in support of the defendant's motion to dismiss filed today. And again, big thank you to Ted Daniel for supplying these documents today. Has really been great with updates from this case all the way through. So the handle is Ted Daniel News if you want to give Ted a follow. And then with this motion to dismiss, we're going to look at the first 8 pages here. So now comes the defendant Karen Reed by and through undersigned counsel and hereby moves this honorable court pursuant to the 5th, 6th, and 14th Amendments to the United States Constitution and Article 12 of the Massachusetts Declaration of Rights to dismiss counts 1 and 3, currently pending against her, on the grounds that the jury reached a unanimous decision to acquit her on those charges. And, alternatively, because there was no manifest necessity supporting the declaration of a mistrial with respect to the charges on which the jury had agreed that Miss Reed was not guilty, and that therefore a retrial on such counts would violate the double jeopardy protections of both federal and state constitutions. So essentially, we need to dismiss these counts because how could you retry her for something that a jury unanimously agreed she was not guilty of? The ancient right to a jury trial is no mere procedural formality, but rather a fundamental reservation of power to the American people. By requiring the executive branch to prove its charges to a unanimous jury beyond a reasonable doubt, the Fifth and Sixth Amendments seek to mitigate the risk of prosecutorial overreach and misconduct, including the pursuit of pretended offenses and arbitrary convictions. Prominent among the reasons colonists cited in the Declaration of Independence for their break with Great Britain was the fact Parliament and the Crown had deprived them in many cases of the benefits of trial by jury. After securing their independence, the founding generation sought to ensure what happened before would not happen again. As John Adams put it, the founders saw representative government and trial by jury as the heart and lungs of liberty. It follows that a jury acquittal is entitled to the utmost respect in our criminal justice system. The Double Jeopardy Clause provides that no person shall be subject for the same offense to be twice put in jeopardy of life or limb. The clause guarantees that the state shall not be permitted to make repeated attempts to convict the accused, thereby subjecting her to embarrassment, expense, and ordeal, and compelling her to live in a continuing state of anxiety and insecurity, as well as enhancing the possibility that even though innocent, she may be found guilty. Perhaps the most fundamental rule in the history of double jeopardy jurisprudence has been that a verdict of acquittal could not be reviewed, on error or otherwise, without putting a defendant twice in jeopardy, and thereby violating the Constitution. That's why, you guys, if someone has a split verdict and on appeal they win their appeal and it's remanded back to the court for a retrial, they're not supposed to be retried for the charges that were acquitted. They're off the table. And here the issue is Judge Beverly Cannone didn't give the opportunity to get these acquittals on the record, to let the jury say, we unanimously agreed that she is not guilty of one or more counts, count 1 and count 3 in this case. Here, the very day after a mistrial was declared, undersigned counsel began receiving unsolicited communications from 3 of the 12 deliberating jurors, indicating in no uncertain terms that the jury had affirmed 12-0 agreement that Miss Reed was not guilty of 2 of the 3 charges against her, including the charge of murder in the second degree. Given the central importance that acquittals have held in our criminal justice system for hundreds of years, this is the precedent, this is the way it has been and should be. The defense respectfully submits that the jury's unanimous agreement precludes re-prosecution of Miss Reed on counts 1 and 3 and mandates dismissal of those charges. Alternatively, to the extent the court believes further factual development is required, the defense respectfully requests that a post-verdict inquiry be held on the issue, and that the court authorize defense counsel to seek additional proof from the jurors regarding their having unanimously acquitted the defendant of 2 of the 3 charges against her, prior to indicating to the court that they could not reach a verdict on the 3rd charge alone. And then we get some background here. So on June 9th, Miss Reed was charged via 3 separate indictments with murder, with vehicular manslaughter, and then leaving the scene. The jury trial began on April 16th, 2024. On June 25th, 2024, the jury began deliberations. On July 1st, 2024, when the jury presented a note to the court, all counsel were ordered to the courtroom. The note was not presented to counsel for review. Rather, the court indicated that the jury was at an impasse. Once the jury was seated, the court then read the jury note verbatim in open court, and without providing any opportunity for defense counsel to be heard, the court declared a mistrial and excused the jury. And then they have this footnote here, and I think that this is important because they state that the note read, they're at an impasse, they can't come to an agreement on charges, plural, as if they were deadlocked on more than one of count 1, 2, and 3. But without the inquiry, without specificity, if you look at the verdict slip, for count 2 alone, there's these lessers here for them to decide on. So that verbiage, that plurality, that footnote is saying, look, they could be deadlocked only on count 2, but said charges because they have 4 possible places they could tick here, and they can't decide if they want to choose guilty of offense as charged, while operating with a blood alcohol level of 0.08 or greater, or if they just want to say guilty of a lesser involuntary manslaughter, or guilty of a lesser including motor vehicle homicide under the influence of alcohol. So that note isn't clear that they were deadlocked on multiple count one, count two, count three. It could have been they were deadlocked what box to tick for just count two. So that's a pretty important footnote there. And I think it's a great point to make. And then it continues to say, in short, neither defense counsel nor the defendant consented to the mistrial, and the court never ascertained from the jury whether its deadlock was in relation to one, two, or all of the charges in the indictment. The following day, on July 2nd, 2024, Attorney Jackson was contacted by a juror in this matter, Juror A, who stated that he or she wished to inform him of the true results of the jury's deliberations. According to Juror A, the jury unanimously agreed that Karen Reed is not guilty of count one, that's the second-degree murder. Juror A was emphatic that the count, second-degree murder, was off the table, and that all 12 of the jurors were in agreement that she was not guilty of such crime. The jury also unanimously agreed that Karen Reed is not guilty of count three, leaving the scene with injury, death. Another day later, on July 3rd, 2024, Attorney Yannetti, that's defense counsel, was contacted by two different individuals, hereinafter informant B and informant C, who had received information from two distinct jurors, hereafter Juror B and Juror C, both of whom were part of the deliberating jury in this case. And I remember the Young Jurks was talking about something like this on their channel. So maybe this is related, or maybe this is who they, their same source. David Yanetti also signed an affidavit here. So informant B sent Attorney Yanetti a screenshot he or she had received from someone, hereinafter intermediary B, of text messages that intermediary B had received from Juror B. In that screenshot, Juror B texted the following to intermediary B. It was not guilty on second degree, and split in half for the second charge. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose. And they're noting here that that's exactly how the message read. Informant C had been in contact with another individual, intermediary C, who was a coworker and friend of Juror C, and joined a Zoom meeting during which Juror C discussed the trial. Informant C sent Attorney Yannetti the below screenshots of his or her text message with intermediary C regarding what Juror C revealed in the Zoom meeting. So we have the first line here from intermediary C. No consideration for murder 2, manslaughter. Started polling at 6-6, then ended deadlocked at 4 no and 8 yes. And then informant C says, interesting. If it was no consideration for murder 2, shouldn't she have been acquitted on that count? And hung on the remaining charges, they spelled it wrong, goes back to the jury verdict slip, that was all confusing. So they're saying the jury verdict slip was confusing. This thing here. And then intermediary C says, she should have been acquitted, I agree. Yes, the remaining charges were what they were hung on, and that instruction paper was very confusing. So now we get into the argument from the defense. The jury's unanimous conclusion that Miss Reed is not guilty on counts 1 and 3 constitutes an acquittal and precludes reprosecution. What constitutes an acquittal is not to be controlled by the form of the action in question. Rather, the court must determine whether the action actually represents a resolution, correct or not, of some or all of the factual elements of the offense charged. And remember, this is a jury trial. The jury is the fact finder. The mere presence or absence of check marks on a form is not dispositive. And I know attorney Andrea Burkhart kind of went bananas calling this out. Like, she really, it's like she saw the future. She saw this is going to happen. And Andrea Burkhart is great, by the way. Subscribe to her channel if you're looking to follow the Idaho 4 case. She's doing great coverage of that too. And she's just all around a very insightful person. But she called it out. There's no place for these lesser charges for someone to say not guilty. So if it came down to jurors getting hung up on these lesser charges, there's no way for them to acquit on, maybe 2, maybe 4, and then say guilty on 3. And if this goes up on appeal, that's problematic because there's no way for there to be some type of dispositive indication that would bar double jeopardy on certain counts, certain charges. So again, they argue the mere presence of absence of check marks on a form is not dispositive. So we can't just say because there is no check for an acquittal, which there wasn't a space for them for those lessers to say, yeah, we acquit on this lesser. The absence of it wouldn't be dispositive. Here, the attached affidavits by attorneys Jackson and Yannetti reflect statements by 3 deliberating jurors that the jury had reached a final, unanimous conclusion that Miss Reed was not guilty on counts 1 and 3. There was nothing tentative about the jurors' statements. To the contrary, they were definitive in describing the results of the jury's deliberations. And they referred to Jackson's affidavit that we looked at. Juror A was emphatic that count one, second-degree murder, was off the table, and that all 12 of the jurors were in agreement that she was not guilty of such crime. In the Yannetti affidavit, reflecting the text messages from Juror B, it was not guilty on second degree. No one thought she hit him on purpose or even thought she hit him on purpose. And again, that's their spelling in that message. So again, there was no consideration for murder two, and Miss Reed should have been acquitted on that count. To hold that this firm conclusion did not amount to an acquittal simply because it was not recorded in a verdict form would be to elevate form over substance in a manner prohibited by the foregoing United States Supreme Court and Supreme Judicial Court precedents. The Supreme Court's decision in Bluford is not on the contrary. There, a juror had reported during deliberations that the jury was unanimous against the charges of capital murder and first-degree murder, but split on manslaughter. The court sent the jury back to continue deliberations, and, when the jury remained unable to reach a verdict, declared a mistrial. The Supreme Court rejected the defendant's argument that the double jeopardy clause prohibited re-prosecution for capital and first-degree murder. In doing so, the court relied heavily upon the lack of finality of the juror's report. The jurors' deliberations had not yet concluded, and it went back to the jury room to deliberate further. Here, by contrast, the jurors' statements reflect a final determination that persisted through the end of deliberations. Even assuming arguendo, and contrary to the foregoing, this court finds that retrial would not be prohibited under Bluford. This court can and should afford broader protection under Massachusetts state law. Unlike the United States Constitution, the Massachusetts Declaration of Rights does not include a double jeopardy clause. But our statutory and common law have long embraced the same principles and protections. And then also, the defense argues that re-prosecution is independently barred because there was no manifest necessity to declare a mistrial on counts on which the jury was unanimously agreed. The double jeopardy clause affords a criminal defendant a valued right to have her trial completed by a particular tribunal. Thus, where a mistrial is entered without the defendant's request or consent, retrial is impermissible unless there was a manifest necessity for the mistrial. Here, Ms. Reed did not consent to the declaration of a mistrial. Absent the defendant's consent, state and federal double jeopardy protections bar, as a general rule, retrial of a defendant whose initial trial ends without a conviction. The rule is rooted in the importance of the defendant of being able, once and for all, to conclude her confrontation with society through the verdict of a tribunal she might believe to be favorably disposed to her fate. Accordingly, the heavy burden of establishing manifest necessity to justify a mistrial is exclusively on the Commonwealth. Before a court declares a mistrial for manifest necessity, counsel must have been given full opportunity to be heard. There's no discretion. And two, the trial judge must have given careful consideration to alternatives to a mistrial. Here, the defense respectfully submits that the lack of opportunity to be heard is alone dispositive. No retrial. Upon receiving a jury note, the court declared a mistrial and excused the jury without consulting counsel. This action was sudden, brief, and unexpected, neither preceded nor accompanied by discussion with counsel. And then they cite here Commonwealth v. Oregon and also Picard v. Commonwealth, which found no manifest necessity where no opportunity was given to counsel to argue the propriety of the question or the necessity of a mistrial. And then Commonwealth v. Stewart, manifest necessity, where the trial judge first ruled that he was going to declare a mistrial, and then, almost as an afterthought, unenthusiastically asked whether counsel objected. The record is independently lacking on the second prong, as it reflects no careful consideration of alternatives to a mistrial. Here, there was one obvious alternative, to simply ask the jury to specify the charges on which it was deadlocked. Had the court done so, and the jury articulated its verdict consistent with the statements of jurors A, B, and C, the double jeopardy implications would have been clear and decisive. Indeed, with virtual unanimity, the cases have applied collateral estoppel to bar the government from relitigating a question of fact that was determined in defendant's favor by the partial verdict. And that's the United States versus Mistrial. And then they also cite Wallace v. Havener. When the jury hands down a partial verdict, a final judgment is rendered on the counts upon which the jury has reached agreement. So if they reached this final agreement, they were absolutely not going to find her guilty. They all unanimously agreed that they were going to acquit her on second-degree murder and leaving the scene. A final judgment should have been entered of not guilty on those two counts. according to the case law. So that was a look at the defendant's motion to dismiss. Of course, I'm sure the prosecution's going to respond, and we can take a look at that. They'll probably cite case law that backs them up. And then let's look at the affidavit of David Yanetti, defense attorney for Karen Reed, in support of the same motion to dismiss. I, David Yanetti, do hereby depose and state that the following is true to the best of my knowledge and belief. I am an attorney licensed in Massachusetts since December 20th, 1989. He gives his office. He's retained to represent Karen Reed. On July 3rd, 2024, I received communications from two different individuals, hereinafter Informant B and Informant C, who had received information from two distinct jurors, hereinafter Juror B and Juror C, both of whom were part of the deliberating jury in this case. To my knowledge, Informant B and Informant C do not know each other. On July 3rd, 2024, Informant B sent me a screenshot he or she had received from someone, hereinafter Intermediary B, of a text message that Intermediary B had received from Juror B. In that screenshot, Juror B texted the following to Intermediary B. It was not guilty on second degree, and split in half for the second charge. When the judge sends us back with that Hernandez thing, and that was an instruction, try to find common ground, try to reason, try to settle your differences. So when the judge sent us back with that Hernandez thing, to look at the other side, it turned into a bully match. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose. They gave us free counseling forms when we left. Based upon the first name of Juror B given to me by Informant B, I believe I'm able to positively identify which juror he or she was and confirm that he or she was a deliberating juror. On July 3rd, 2024, Informant C contacted me to say that he or she personally knows Juror C, as they used to work together. Informant C and Juror C also have a mutual friend, hereinafter Intermediary C, who is a current coworker and friend of Juror C. Informant C told me that he or she had posted something about the Karen Reed case on Facebook on Monday, July 1st. He or she told me that he or she believes the post led Intermediary C to text him or her and inform him or her that Juror C was a deliberating juror on the case. Informant C told me that he or she thereafter reached out to Juror C via text message and discussed his or her experience as a juror in very general terms. They discussed what an exhausting experience it was and that Juror C was relieved it was finally over. Intermediary C told Informant C that Juror C would be participating in a Zoom meeting with a number of friends to discuss what happened with the trial. Today, Informant C sent me 3 screenshots of a text message exchange he or she had with Intermediary C. Informant C told me that Intermediary C was reporting to him or her during this exchange what Juror C had revealed during the Zoom meeting. The text message exchange reads as follows. No consideration, and so this is all going to be from Intermediary C. No consideration for murder 2, manslaughter started polling at 6-6, then ended deadlocked at 4 no and 8 yes. She was very consistent in the fact that they could only consider things that were admitted into evidence. Ultimately, she voted no because the cause of death was twofold of hypothermia and head injury. He or she was convinced that the vehicle did not cause both. The whole jury felt intimidated by Higgins' presence at the end. She's not sure what she's going to do. She's going to lay low for a couple days and see where it takes him or her. Hasn't ruled out anything. The jurors all have a group text going. And then Informant C says, interesting. If it was no consideration for murder 2, shouldn't she have been acquitted on that count and hung on the remaining charges? Goes back to the jury verdict. And we're going to get to, it's going to say that the jury verdict form is confusing. Yeah, so the jury verdict slip, that was all confusing. Intermediary C says, she should have been acquitted, I agree. Yes, the remaining charges were what they were hung on, and that instruction paper was very confusing. Informant C, what a great experience for him or her. Amazing that they let the Alberta in the last day. Oh, maybe Alberts, meaning the Alberts. Intermediary C, he or she felt very honored to be a part of it. He or she was redacted physical description of Juror C. Everybody else was from a professional walk of life. They all got along and never heated. They agreed to disagree and respected each other. Informant C, that's the way it should be. O knew it was an intelligent jury. Maybe that means I. They will be studying this case in law programs for years to come. How not to investigate and try a case. Maybe that's supposed to be I.E. If they all agreed on no for murder 2, they should make that clear to the DA and the court. It's basically a case of double jeopardy if she's retried on that charge. And then back to Yannetti. based upon the description of Juror C given to me by informant C and confirmed by the redacted content of the above text message exchange, I am able to positively identify which juror he, she was, and confirm that he, she was a deliberating juror. Signed under the pains and penalties of perjury on the 6th day of July, 2024. So there you go, you guys. What do you think about the Karen Reed trial, the hung jury, the mistrial, anything that's played out? And what do you think of the details included in these affidavits? And secondly, if the prosecution takes this seriously, do you think they're going to push to try to retry on second-degree murder? And if all they have left on the table is manslaughter, but they also have this information that, the jurors, at least half of them, had questions about whether or not this vehicle was even the cause of John O'Keefe's death. Would you, as a prosecutor, retry just for that manslaughter charge? What would you guys do? Turning the floor over to you guys. Let me know any and all of your thoughts. You guys all take care.